The jury has just given you $5 million as full and fair compensation for the harms and losses and damages you suffered because of this doctor's carelessness. How quickly can you get that money? Would you like to know the answer? Come join me for a walk through this beach area as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You suffered physical harm and injury as a result of a doctor's carelessness. And now your doctor refused to acknowledge that he did anything wrong. He refused to take responsibility for what he did. And now you had no choice but to go ahead and bring a lawsuit against him, claiming that now you suffered significant harm and injury, and you had no other choice because you are now physically disabled from doing those activities, including your work, that you used to be able to do. During the course of your litigation, the doctor again refused to acknowledge and accept responsibility for anything that he did to you. He claimed he did nothing wrong. He also claimed that you, the injured patient, caused your own injuries. Then he turned around and said, listen, even if I did something wrong, and so did you, Mr. Patient, guess what? Whatever I did not cause or contribute to your injuries. And then he said, you know what? If I did something wrong and I caused you harm, your injuries really are not as bad as you claim them to be. So those are the typical and most common defenses that we see in these medical malpractice cases, and in your case, the doctor used every single one of them. So what did that mean? It meant that your case went all the way to trial. So now, 2 or 3 years after you started this lawsuit, your case finally went to trial. After 3 long weeks of being on trial, a jury, members of the community decided that yes, your doctor violated the basic standards of medical care, and that yes, as a result of those departures from the standard of care, that caused you significant harm and injury. And then it came time for them to determine how much money you were to receive as a result of the doctor's carelessness. And the jury determined that in total, for your past pain and suffering, for your future pain and suffering, for your future lost earnings, you are entitled to receive $5 million in total for all of your harms and losses and damages. You are thrilled. You are overjoyed. You are finally happy. Why? Because the jury did the right thing. And now you are so excited, the only thing in your mind is, excellent, when can I get that money? You're not getting it very quickly. And you might be thinking, wait a second, the jury has now spoken. The jury has determined that you are entitled to receive $5 million. Do you think for a second that now the doctor takes out his checkbook and now writes you out a check for $5 million and you go home and that's the end of it? The answer is no. That's not what happens. Because here's exactly what will happen. The moment the jury comes back with their verdict, and now they give you $5 million in compensation for all of your damages, the very first thing that's going to happen is the defense attorney is going to jump up out of his seat as if an ejection button was pressed and yell out, "Judge, this is ridiculous." Not in those words, but he's going to say, "This is ridiculous. The verdict is not consistent with the evidence and the testimony in this case. I ask that you throw out the verdict." Throw it out, because it does not consist and comport with the evidence and the testimony in this case. So throw it out, Judge. Give us a verdict in our favor. Give a verdict for the defense. Change the jury's verdict and give it to us instead. That's the first thing the defense attorney is going to do. So what's going to happen next? The judge will then have to make a decision about whether he agrees or disagrees with the defense's request. Now, in most instances, the judge is not going to make a snap decision on this particular request. Why? Because in all likelihood, the judge is going to give the defense lawyer an opportunity to obtain the trial transcript, and now to go ahead and make a legal argument based on the trial transcript and the testimony and the evidence that's been presented, and give him a few months in order to compile all that information and to make a cogent, coherent argument as to why the judge should throw out this particular verdict. Likewise, your attorney, the plaintiff's attorney, will then have an equal amount of time in which to reply and to respond to that particular argument. The judge is going to take a number of months in which to read all of those arguments and then render a legal decision. So just to get to that point could be many months after your verdict, just to get to that answer and decision about what the judge is going to do with this particular verdict. Based upon the judge's ultimate decision, you're thinking, terrific, if the judge agrees with you, that's it. The defense has to write their check for $5 million, and now your case is finished and done. Well, hold on. No. That's not how it works. You're not getting your check so fast. And you might be thinking, okay, I don't understand. The jury gave you a decision. The judge now gives everybody a couple of months in which to put together this argument. Then he takes a number of months in which to render a decision. That should be it, right? No. Because if the judge agrees with you still, and says, you know what, I'm not going to touch the jury's verdict. I believe that there is sufficient evidence in which to uphold this verdict. And therefore, plaintiff, you win. The defense, sorry, no go. Your request is denied. In that instance, do you think that the defense is going to take out their check and write that check for $5 million? In all likelihood, the answer is no. Okay, so what do they do next? What they do next is they're going to appeal. And you're saying, how could they appeal? The judge just rendered a decision. And the reality is that in every case in New York, from a decision involving the trial, as well as the trial judge's decision not to turn over or overturn the verdict, the defense may have an opportunity to go ahead and appeal. And there are many different legal considerations about deciding whether or not they think they have grounds for appeal. If the defense goes ahead and files an appeal, they are going to have a period of time in which to go ahead and prepare arguments in which to file their appeal. It could take months in which they have to file that appeal. During that time, you are not receiving that $5 million. Now, if they go ahead and do file an appeal, guess what? Your attorney then has a number of months in which to respond and go ahead and oppose that appeal. All right, you're thinking, terrific. Now it's just going to be a couple more months, just like what happened with the judge in the trial level. The answer is no, that's not what happens. Because after the defense attorney puts together the appellate argument, now your attorney has to put together an appellate argument. Many more months have gone down the road. And you're thinking, okay, now this is going to be pretty quick. Now the appellate court is going to look at these arguments and give us a quick decision. No. It could be an extended period of time. It could be 6 months. It could be a year before the court actually hears oral argument on your particular appeal. And then, after they hear oral argument, it could be weeks, it could be months before they reach a decision. And you're thinking, okay, it could be another couple of months, it could be 6 months, it could be a year. I'm in it for the long run, I'm in it for the long haul. Fine, we've already come this far. Well, guess what? You are now waiting for an appeal. You're now waiting for the decision. And you're thinking, okay, if you win, that's it. The case is over. Well, maybe yes, and maybe no. When you take an appeal, there could be many different outcomes. One outcome is, yes, the appellate court agrees with the trial judge and agrees that you should get your verdict. That now your $5 million, you are entitled to receive your $5 million. And in New York, you will be entitled to receive interest from the date of the verdict up until the time that the appellate court reaches its final decision and agrees with you. That would be the time in which the clock starts to run, in which the defense has to pay. You would receive interest from the time of the original jury verdict up until the time that the final decision is reached. That is the best outcome for you. However, there are many other possible outcomes from an appeal. And the problem is, when you're going into an appeal, neither you nor the defense knows exactly what's going to happen. Did you know that the appellate court could turn around and say, you know what? We agree with the defense. This verdict should not stand and is not supported by the evidence in this case. We are throwing the verdict out. And we reviewed all the pleadings in this case. We reviewed the complaint. We reviewed everything else. And you know what? We don't think your case has merit. And now they throw your entire case out. And you know what you get? Absolutely nothing. There are other options. The court could decide that the verdict, that the amount of money that you received is too low. In which case, they can go ahead and increase that amount of money. And if the defense refuses to accept that, they will often be given that opportunity. They say, listen, we are going to increase the amount that the jury has given you. And if you don't like it, fine, we are going to send you back to trial and try this case all over again on the amount of damages you are to receive. That is an option. On the other hand, the appellate court could turn around and say, you know what? We think that this verdict is too high. We're going to reduce it to some number. And now, either you agree or disagree. If you agree, fine, you take it, and now that's the end of the case. Now the time starts to run in which the defense has to write you a check. On the other hand, if you and your attorney do not agree to that reduced amount, guess what? In all likelihood, the appellate court is going to say, fine, we're going to send you back to trial. You go ahead and try your case all over again, most likely on the issue of damages, and now let another jury decide whether or not and how much you are to receive. So why do I share this quick information with you? I share it with you hopefully to open up your eyes, to show you exactly what happens when and if a jury comes back and awards you $5 million in a medical malpractice case in New York. You think you're getting that money right away. The reality is, it's not going to happen that quickly. You know, I recognize you likely have questions or concerns about your own matter. Well, if you are thinking about bringing a lawsuit against a careless doctor or careless hospital staff, and you have not yet done so, and this matter happened in New York, and you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.